And so our next session is a panel discussion that I will be monitoring. And I'd ask Stephen Crombie, the Senior Director of Public Affairs for Ontario Road Builders Association, Jules Arntz-Gray, the newly minted ADM of the Fair, Safe, and Healthy Workplaces Division, responsible for inspection and employment standards, and the Health and Safety Branch, and Sobi Raghunathan, the Vice President of Operations Strategy for 4S. We're going to have a conversation about the government's continued move to modernize the health and safety system, including the recent announcements that came out on Bill 30, which is Working for Workers Act 7. Over the past, 5 years, there have been 7 iterations of it. I'll just give you a little background. Stephen is the Director of Policy, Public Affairs for the Ontario Road Builders Association, and he brings a lot of experience in heavy civil construction policy, years of experience in navigating intricacies of policy making and regulatory items. He's worked politically, and he has a proven track record of advancing the practices and priorities of the construction industry. Jules Arntz-Gray is the recently appointed Assistant Deputy Minister of Fair, Safe, and Healthy Workplaces, and prior to his appointment, he was the Director of the Occupational Health and Safety Branch within the ministry, the Director of the Training and Awareness Branch. He worked for me at one point in time. Again, one of the seasoned COVID veterans, has over 20 years experience with the ministry and has responsible for the 600 plus inspectors, and he is an inspector himself, so he's very familiar with the front line. And Sobi Raghunathan is a graduate of the Metropolitan University in occupational safety. She's got 20 years experience, a co-founder with her husband Sebastian 4S Consulting, responsible for building the model that is here today. Sobi's actively involved with government, associations, the Ontario OGCA, as well. She is an associate auditor under COR, ISO 45001, 2018 lead auditor, and active with the League of Champions and other associated programs in the safety industry. Sobi is also the co-author of an upcoming book called Creating Awesome Corporate Strategy Culture, and a book of creating sustainable culture of Canadian workplaces. And Sobi uses the word awesome all the time, which is awesome, Sobi. Anyway, the Occupational Health and Safety Act under Bill 30, there were a number of changes. One is that it was amended to provide health and safety management systems accredited under that section must be treated with equivalence. So you have COR 2020 and you have ISO 45001. We're going to have a quick conversation about that. And what's also important, especially for people, business owners and association representatives here, is Part 9.1 of the Act establishes an administrative penalty theme. And I recall when Jody Young, previously the ADM in Alberta, they had a structure of administrative penalties with respect to, as opposed to assigning a fine, they would assign a task judicially. You have to take a health and safety management program or something to that effect. I know this is a beginning with administrative penalties. We're just going to suss that out and maybe see what's happening in the future. And lastly, Bill 72, which is the Buy Ontario Act, we're going to have a quick discussion about that. So I'm going to jump kind of right in. And remember that the health and safety management systems, the Health and Safety Excellence Program, CORE, they're all interconnected, and we just want to be able to see how these new things are going to affect things. So I guess the first thing I'll throw out is, what does equivalency between CORE and ISO really mean for safety system recognition? And how can government and owners protect the value of both credentials without turning them into a box-checking exercise? And further, recognize that buyers of construction, large contractors, must comply by having CORE, And if other industries such as manufacturing or others choose to use ISO, how do we encourage them to move forward? So I'll kick it off.
Thank you, Ron. ISO COR, any program, safety management system, is really a good way to get an organization started on their health and safety management system. And we always advise, between COR and ISO, pick what's right for you and what's right for your industry. So one of the advice that we typically give to our clients who are kind of at that juncture trying to decide, should I choose ISO or should I choose COR? We always say, what sector are you in? Are you a locally run business? Are you only operating in Ontario? Or are you looking at actually doing business across the province? These are questions that you should be asking. What sector are you in? Is it only local business or across the country, across globally? If you are global and if you are across the provinces, ISO is a great solution for you because it's internationally recognized standards. If you are local, COR is a great way for you to get started because COR is Ontario-based. It's local, especially for small businesses who are looking to get started. It's very structured. It's easy for organizations to follow through. So it depends on the business they're in. If they're in manufacturing and thinking about actually going to other provinces, ISO is a great way to get started because then they can tie in other ISO management systems like ISO 9001 and 45000 for safety management together. When they manage a couple of management systems together, safety sustainability is increased. Safety is always seen as something, it's a cost center, it's nice to have. If bidders are asking or buyers of services are asking, we'll go get it, but otherwise, why am I investing so much of resource time into management system? It takes time. And for smaller businesses, if they are not looking for COR or ISO, get started with safety excellence. I hope I answered that question, Lon.
Okay, thank you. Jules.
Perfect, yeah, couldn't agree more. And yeah, from the government perspective, we just encourage the use of health and safety management systems. First off, they are not required, okay? So, but what we know is the reality of the market is that procurers who are procuring construction often are putting this into the process that's saying you have to bid, and they were saying you had to do COR. The government looked at that and said, we're really glad that procurers want people to use COR, but we were getting a lot of complaints saying, I'm a global company, I came in here to bid on this project, I have ISO, why do you not recognize that when your own chief prevention officer recognizes ISO? There's actually 5 standards we recognize that the chief prevention officer has recognized, and so really any of those we consider equivalent. But in reality, it's usually ISO COR in the space that people are talking about. The idea is that standards, health safety management systems take you above and beyond. The Act is like that bare minimum standard. Our inspectors are out there, and they're not pushing you to the best levels. They're bringing you to the floor. That's all they can do legally. But to truly move health and safety forward, you really need to have a fully integrated management system. We know that. The Act doesn't require it, but I always encourage employers to do that. That's why the Chief Prevention Officer has a recognition program. If you do have ISO or you have COR, you can actually be recognized by the Chief Prevention Officer. You can get financial incentives from the WSIB because of it. You can get recognition. You can advertise that the government has recognized you. All of that, you can use it in your branding. We encourage that, but that's, when it comes to the procurers, our message to procurers is, don't just pick one system. Any of the systems that the Chief Prevention Officer has recognized are fine by us, and so that's the message we've said to the procurers. And importantly, this only applies to public sector procurers, so buyers of construction, like a municipality, Metrolinx, et cetera. So an Ellis Don that is doing its own procurement, they're allowed to continue to do whatever process they wish. This is the government saying to our fellow government colleagues at all levels, municipal, provincial, that if you are buying construction, you need to recognize any of the health and safety management systems.
Stephen, you represent a lot of big guys. What's the sort of feeling out there about this?
Yeah, no, thanks so much, Ron. And perhaps just a very quick history lesson on the ISO COR accreditation in Ontario. Going back to 2018, there was a movement from the leadership of the ministry, of course, Ron, yourself at that time as Chief Prevention Officer, to establish an accreditation of occupational health and safety management systems. At that time, of course, both ISO 45001 and COR 2020 were recognized as accredited health and safety systems. So there was a big push across the industry for firms and procurers of construction to require an occupational health and safety management as a condition of pre-qualification in order to bid on these public contracts. What we had seen from 2018 up until effectively the passage of the Act was a bit of misinformation, I would say, on behalf of public owners and buyers of construction, where they believed, they understood that there was actually a delineation of the standards, and that one standard perhaps was superior to another standard, and effectively it was creating confusion in the market. And in some respects, acting as a barrier to entry. And I know a lot has been talked about interprovincial trade barriers. Effectively, what we saw was occupational health and safety management systems were becoming an intermunicipal trade barrier. And so there were examples, don't want to throw the city of Kitchener under the bus, but they in fact didn't recognize ISO 45001. We had large firms that, as Sobi mentioned, that are multinational, and ISO makes more sense for them. And so we did flag this for the ministry, and full credit to Minister Piccini and the hardworking folks at the ministry for listening to industry's concerns and communicating that directive that these accredited standards should be looked at as equal.
Thank you, and I'll just make a comment about one of the concerns that health and safety management systems have by others that are viewing it as a challenge. It's like healthcare accreditation. You get a 5-year accreditation designation, and 6 months before the next accreditation, heads explode as people run around trying to make things right. It's like when your mother-in-law comes over, you clean the house so they don't really know how you live. So, we've got to be sure that any accreditation system has the checks and balances to make sure that that it's not just perceived as a tick box.
There's one more point I will add to that, and thanks, Stephen, for stressing why COR and ISO clarity was needed by the ministry. At Forest, I'm one of the core external auditors among 20 plus auditors in Ontario, and we support many core clients in Ontario. But we chose to go for ISO 45001, nothing against COR, but because we have a lot of clients across the province, as well as we are serving a lot of clients outside the country as well. So for us, ISO 45000 made sense, and we did it as an integrated management system. So we went for 9001, 45001, and 14001 together as an integrated management system for forest consulting. And then we also went for 27000 for cybersecurity, because we are a software company as well. And then we applied for SOCI, because we want to be setting the example to other companies, saying that, once you get your certification, whether it's COR or ISO or SAT 1000, go for SOCI. So become Ontario's accredited organizations.
That's great. The other important part of this act was administrative penalties, and they can improve compliance, but how should they be designed so they drive prevention rather than punishment, especially for repeat issues versus one-off administrative failures? So can you define how administrative penalties under the Act current will work? And then the follow-up question from a regulator perspective, and certainly from business, is this just a foundational move that could be built on to lead to other opportunities from administrative? Let's go ahead, Jules.
Yeah, happy to do that. So yeah, we're actually really excited to be adding the first ability to have administrative monetary penalties under the Occupational Safety Act. So a lot of people, in case you might be like, what is that? This sounds like a legal term. What does that mean? So currently, if you've ever met our inspectors, they go out, they write orders. So an order is, hey, that machine isn't guarded. I need you to guard that machine by such and such a date, or if it's really hazardous, stop work. You cannot use it at all until you fix it. The other things that you're familiar with is we write what are people called tickets. We call it a certificate of offense, and it's tickets, just like a speeding ticket. You get a ticket for not wearing a hard hat. And then the more serious items, we do what's called a Part 3 prosecution. This is where we take you to court, and we're charging you. Fines can be, $100,000, $500,000, $1 million, depending on the severity of the issue. What tool we did not have in the toolbox is what we call administrative monetary penalties. So these are, in the simplest plain language way, they're like tickets. It'll feel like a ticket to you because we go in and we make a decision right there and say, I'm issuing you this penalty. But it is not done through the court process. You do not go to court. If you want to appeal it, it's a completely different process. It's handled within the ministry. It's, to be short, it's much quicker for both of us, both parties. It's like, we issue it, you pay it, it's done, there's not court processes and all of that. If you have a complaint or want to go through, say, I disagree with this, it's all handled in the ministry and it's quite different. What it is it's a tool that allows us to be much more nimble to try to push behavior change or organizational culture change. But yeah, Ron, to your point of, are we going there? Is it just to be punitive? We already have administrative monetary penalties in other legislation. So our employment standards officers, they use them. And our inspectors, health and safety inspectors, also use them in BOSTA. So BOSTA is the skilled trades training. So if I walk up, I see an electrician, and I'm like, hey, are you a journey person or are you an apprentice? If they're not, I'm going to stop them from doing that work. I may issue them what we call an AMP. And the point is to really get change, but we don't use them that often. So an example in BOSTA, where we've had them for a few years now, we did 4,000 orders in BOSTA this year. We wrote 6 AMPs. So we don't jump to AMPs. AMP is, we're always going to go to education first. We do what's called the compliance continuum. I'm going to teach you what is wrong here first. If that's not working, I might need to go higher up. I'm going to do orders or stop work orders, and then tickets or AMPs, and then a Part 3 prosecution. If you're responding to those easier, like the education, the orders, we don't need to go any farther. Our aim is to get you into compliance. If I come back and you're doing the same thing again and again and again, you're not really getting that softer approach. And so we're going to use the other tools in the toolbox, and that's what the AMPs are for. The other piece, though, slightly different than the AMPs that you mentioned, is creative sentencing, and that's something that we've also added into the Act. It's not yet in force yet, but in other provinces what you see is instead of just a fine, you can be ordered to, you need to pay for and develop a health and safety training program for your industry based on the accidents that cause these fatalities and things like that. We have now modified the Act and allowed the authority to us. We didn't have the authority before to give to the courts to say you can give a different type of sentence than just monetary. We've given us that authority, but it now needs us to create a regulation to make it come to life. We're in the process of that, so there isn't a regulation yet.
I think it's really interesting. Like, Stephen and Sobi, sort of Stephen from an industry perspective about the change in administrative penalties, but also the creative sentencing and how that's being perceived by the industry, and certainly from a Sobi's perspective, how can safety systems articulate this change to its members, in fact, everyone involved in safety. So, Stephen.
Yeah, thanks, Ron. Look, I'll be very frank. Industry does not like fines. But what I would say to that is administrative monetary penalties are something that the industry is familiar with, whether it's authority through the Building Opportunities in the Skilled Trades Act or the Ontario One Call Act, the Ontario Underground Information Notification Systems Act. If a contractor is beginning an excavation without appropriate locates, they are subject to administrative monetary penalties. And so the notion of a fine associated with non-compliant behavior is something that we're quite familiar with. At ORBA, part of our pillar of our mission is to ensure the highest level of health and safety. And so we welcome any tool available to the ministry to enhance health and safety and curb bad behavior. I will speak briefly about creative sentencing because in other jurisdictions such as Alberta, this has been implemented, and we've actually seen a change in behavior where, for instance, if there is a systemic failure within an organization, the introduction of a health and safety management system as part of the sentence has yielded a safer work environment. And so we are quite excited about the ministry's authority to be able to issue creative sentencing, and we think that it will actually enhance safety outcomes across the province.
I think administrative fines are needed for players who are really not very safety conscious. Depending on the industry and depending on the sectors they serve, their safety culture differs. Especially if they are a COR or ISO client, they would have better safety management systems and better safety culture, and where this doesn't really apply to them, and you could go to the sites and their sites are very well maintained, or their manufacturing facilities are very well maintained, and where you don't need to really worry about giving them the fines. But there are places where you do need, it's like traffic tickets. You know, if we don't have traffic tickets, all of us would be speeding. There's no limit to anything. But because there are tickets, then we are where the policeman is there. We slow down and we actually tend to pay attention and say, you know, we have to be a little cautious. That's how I look at administrative fines, and it is needed, especially for people who haven't chosen a safety management system or haven't taken that path forward. This is a little slap in the wrist is needed for them to pay attention.
Yeah, I'll just follow up comment on that because I think that's a really good point. Is that I will probably say that most of the people in this crowd are not the crowd we're looking for AMPS, because you're here at this conference. Not everyone's like you, okay? So who we bump into each and every day as inspectors are people who do not want to see us, wish we did not exist, and don't know about safety and are really annoyed by it. So, you know, that's why we have different tools in the toolbox. When we're talking about things like health and safety management systems, I mean, these people can't even do the bare minimum of the act. They're not in that best practice space.
I think one of the really good things that we did back in the day, and credit Rod Cook in the design of the Health and Safety Excellence Program, it fits within the ISO, the COR, and other safety systems to allow people to progress through something to an ultimate goal, which is supporting Ontario's safe employer. So the good part about it is when you move to creative sentencing or an administrative approach, there are mechanisms that are currently in place to help people get through that. So we look forward to it. I think I'm going to cut it off there and thank the panel. We did want to talk a little bit about Bill 72, which is by Ontario. Very quickly, it is simply the government's way of supporting Ontario and Canada in light of the geopolitical situations. So, you know, it may have some ramifications on business. The lowest bidder is now the lowest bidder of available products as opposed to globally the lowest bidder. However, I think we will work through that as this thing gets implemented. So, big hand for the panel.